Good morning, this is your Kelso Report for Wednesday, August 22nd, and I'm your host, Clark Kelso. We begin with a federal question jurisdiction issue in the Ninth Circuit. The plaintiff in Cook Inlet Region versus Rood was an Alaska Native Regional Corporation formed under the Alaska Native Claims Settlement Act, a federal statute, ANSA. The defendants were shareholders and former board members of the plaintiff. The plaintiff filed suit against defendants alleging that they had violated ANSA and Alaska law in the course of trying to secure approval of a petition that, if approved, would have removed certain restrictions on the alienability of the stock of the plaintiff corporation. The district court held that it had federal question jurisdiction over the ANSA claims and supplemental jurisdiction over several state law claims. It entered judgment in favor of the plaintiffs on the first ANSA claim. On appeal, the defendants challenged the court's subject matter jurisdiction. The issue arose because ANSA incorporates Alaska state law regarding the manner in which proxies may be solicited, and the defendants rather creatively argued that the key issues in the case arose under state law. This argument, of course, entirely misses the point that the cause of action still arose under ANSA, which is very much a federal statute. As the court explained, there is federal question jurisdiction over a federal law claim simply by virtue of its being a claim brought under federal law, whether or not it incorporates state law. Nice try by the defendants. Next, a case interpreting the federal wiretap statute. Even criminals get to make to-do lists. I'll say that again. Even criminals get to make to-do lists. That appears to be the rationale in United States versus McTiernan, where the Ninth Circuit interpreted the federal anti-wiretapping statute. In this case, John McTiernan, a famous Hollywood movie director, had hired former private investigator Anthony Pellicano, back in the year 2000, to illegally wiretap the telephone conversations of two individuals. 6 years later, when the FBI questioned McTiernan about Pellicano's activities, McTiernan claimed that he knew nothing about any wiretapping. But the FBI had obtained a digital recording that Pellicano had made, unbeknownst to McTiernan, of a telephone conversation in which the two men discussed illegal wiretaps. McTiernan was prosecuted for making a material false statement to the FBI. Once again, as we all know, it is the cover-up that gets you. McTiernan argued that the recording should have been suppressed pursuant to Section 2515 of Title 18, which prohibits the introduction into evidence of the contents of a wiretap where, as relevant to this case, the wiretap was for the purpose of committing any criminal or tortious act. Following the lead set by a number of other circuits, the Ninth Circuit held that the statute applied only when the recording is done for the very purpose of facilitating some other criminal or tortious activity. In this case, the evidence established that at most, Pellicano made the recording for the purpose of reminding himself of the instructions that McTiernan was giving him. According to the Ninth Circuit, even though the recording may have been intended as a to-do list of criminal activities, that does not mean the recording was made for the purpose of committing a criminal or tortious act. Apparently, even criminals get to make lists. Next, a case involving competency. The defendant in United States versus Dreyer began, at age 63, to experience the onset of frontotemporal dementia, a degenerative brain disorder that causes changes in personality and behavior, impairs social interactions, and causes disinhibition and a loss of insight and impulse control. He was a practicing psychiatrist at the time. From the age of 66 to 69, despite having no criminal history, he participated in a conspiracy to distribute controlled substances, and in December of 2010, at the age of 73, he was sentenced to 10 years imprisonment after he pleaded guilty to charges related to that conspiracy. At the sentencing hearing, the district court was provided with 3 expert reports. All 3 diagnosed the defendant with frontotemporal dementia and noted that he exhibited textbook manifestations of the condition. The defendant did not allocute at sentencing, and defense counsel informed the court that his client would not address it due to the dementia's effect on his behavior. Somewhat surprisingly, defense counsel did not move for a competency hearing. But the district court also did not order a hearing sua sponte, notwithstanding the evidence. The court sentenced him to 120 months. On appeal, the defendant contended the district court erred by failing sua sponte to order an evidentiary hearing to determine his competency at the time of sentencing. A split panel of the Ninth Circuit agreed, holding that the district court committed plain error by failing to order a competency hearing, since the record before the court created very clear doubts as to the defendant's competency. Next, an environmental law decision. The U.S. Fish and Wildlife Service had promulgated regulations under Section 101A5A of the Marine Mammal Protection Act that authorized incidental take of polar bears and Pacific walruses resulting from oil and gas exploration activities in the Chukchi Sea and on the adjacent coast of Alaska. In Center for Biological Diversity versus Salazar, suit was brought to challenge those regs under the Marine Mammal Protection Act, the Endangered Species Act, and the National Environmental Policy Act. The district court granted summary judgment to the service, and the Ninth Circuit easily affirmed. The service had permissibly determined that, consistent with the statutes, only relatively small numbers of polar bears and Pacific walruses would be taken in relation to the size of their larger population, and the service's extensive documentation and environmental assessment complied with the Endangered Species Act and NEPA. Next, the California Supreme Court in a workers' comp decision. The employee in LaFille Manufacturing versus Superior Court was injured in the workplace by a power press that did not have the proper point of operation guard installed. Now, normally, of course, workplace injuries are governed exclusively by the workers' comp law, and there's no civil action in torts for such injuries. However, certain injuries have, by statute, been excluded from the workers' comp exclusivity doctrine, and power press injuries are one of those statutory exclusions, according to Labor Code Section 4558. So the employee brought a civil action for his injuries in the Superior Court, and he also brought a claim for his wife's loss of consortium. The issue before the California Supreme Court was whether the spouse of an injured worker may claim damages for loss of consortium in an action at law brought by the injured worker against the employer. Well, the court unanimously rejected the spouse's claim, noting that Section 4558 created an exemption only for the injured worker, and that absent the exemption, claims arising from industrial accidents fundamentally remain compensable only under the workers' comp system. Under the settled principles of workers' comp law, the exclusivity rule bars a dependent spouse's claim for loss of consortium. It seems to me that while the court's conclusion is one reasonable interpretation of the statute, it does stretch common sense just a bit to think that the legislature would have wanted only the employee, but not the employee's spouse, to benefit from the exemption. After all, the legislature's focus here was surely upon the high risk of danger from unsafe power presses, and not so much upon whether the employee's spouse should benefit from the exemption. We'll see if the legislature doesn't take a look at this topic in next year's legislative session. And that's it for today's Kelso Report. Have a great day in the law.